How to avoid implied contracts in employment. Imagine starting a new job and feeling unsure if your position is truly secure. Sometimes, what employers say or do can unintentionally create legal obligations. That's where implied contracts come into play. An implied employment contract is an unwritten agreement formed through actions, conduct, or statements rather than clear written words. These contracts can limit an employer's ability to dismiss employees at will, often requiring a good reason for termination. To keep things simple and clear, employers need to manage their communication and practices carefully throughout the employment process. First, always use clear, written employment agreements. Make sure every job term is documented in a contract or offer letter. Clearly state that the employment is at will, meaning either party can end the relationship at any time for any lawful reason. This written statement helps prevent courts from assuming there are additional obligations based on actions or words. Second, avoid making promises or statements about job security. Do not verbally or in writing guarantee employment duration, promotions, or raises unless these are explicitly included in the contract. Casual remarks or policies that imply job security can be seen as creating an implied contract. Be cautious about what management says during interviews or performance reviews. Third, apply policies consistently. If you have disciplinary or termination procedures, clarify that these are guidelines, not contractual guarantees. If policies are enforced inconsistently or employees are led to believe they cannot be terminated without following certain steps, it might create an implied contract claim. Fourth, include disclaimers in employee handbooks. Clearly state that the handbook is not a contract and does not change the at-will employment status. Avoid language suggesting employees have a right to continued employment or specific disciplinary procedures unless explicitly agreed upon. Fifth, train managers and supervisors. Educate them to avoid making promises or statements about job security that are not part of formal agreements. Their words can be used as evidence of an implied contract if they suggest employment is guaranteed. Sixth, review and update employment documents regularly. Make sure contracts, handbooks, and policies stay clear and consistent with at-will principles. Remove or revise any language that could be interpreted as creating contractual obligations. Lastly, avoid practices that create reasonable expectations. For example, treating employees as if they have guaranteed employment or following a strict disciplinary process before termination can lead employees to believe an implied contract exists. Clarify that such practices are at the employer's discretion. In the end, preventing implied contracts boils down to clear communication, written agreements, and consistent employment practices. This approach helps protect the employer's ability to manage the workforce flexibly while respecting legal boundaries.